Hello friends, welcome to my channel. The very recent development that has happened into the country and the topic that I have chosen for today's discussion is that it is the question of the Constitution. The very appointment of Supreme Court and High Courts judges by the India's collegium system. Collegium system is five top judges, members of Supreme Court, who actually consist of CJI, Chief Justice of India, and four other top judges. So the collegium system actually does appoints in higher judiciaries of the country judges. But the recent development that becomes the news is that Jagdeep Dhankar, the India's current vice president, actually raised the voice of he condemned the judicial appointments of judges by the collegium system. In 2014, when a recent BJP-led government came to power in 2014, after 3 months, BJP-led government, means central government, wanted to change the appointment of the judges. So what they does is they passed the National Judicial Commission, Appointment Commission, NJAC Act by the Indian Parliament, and this act actually through this act central government wanted to change the going course of judicial appointments. Though as law is bent into the Supreme Court to scrutinize for judicial review, this very Supreme Court actually repealed the bill. Actually, he said that it is violation of the basic rights, basic structure. Actually, the independence of judiciary was being compromised by this NJAC Act, and Supreme Court actually declined to accept that. So into our constitutional framework where we are living in, you just see and watch our preamble have been incorporated into the separation of powers. Okay, republic, separation of power, democratic country. In a democracy, people's voice is very great significance, as the constitutional first line is that be the people of India. The constitution derives the power from the very people of this country, and the whole constitution is valid to all. So in the separation of power, there is three things: legislature and judiciary and executive, and their powers are divided. But the what a statement made by the vice president, current vice president Dhankar ji, he said that the parliament sovereignty cannot be questioned. That means that if the law is passed by the Indian Parliament, the Supreme Court cannot decline. So he's actually calling, saying that the Parliament sovereignty is supreme. But that is not the case in a case of India. The Parliament is not supreme. Sovereignty of Parliament is, yes, it is accepted, but it is not supreme. Constitution is supreme. And in this constitutional framework, everybody has the separation of power. Legislature have given the authority to legislate laws, to make the laws. MPs, member of parliaments, and state assemblies members, they have the right to make only laws. They are parliamentarians. They didn't have the authority actually to override and show the superiority in case of this law. And these laws can be questioned. The laws made by the parliament can be questioned into our Supreme Court and High Courts as well. This question is actually asked into the prelim examination in IAS, that the laws made by the parliament can be scrutinized in High Courts. Yes, it is, and Supreme Court as well. So actually it is because of his at the second highest rank, vice president in a office of presidents. So his voice is very valuable and have weight. But in case of India, what he said is wrong. Knowingly, unknowingly, I don't know. He proclaimed whatever he made the statement, but in the Britain Parliament, yes, it is valid. Britain Parliament is sovereign and supreme. Only British Parliament cannot make a woman a man and a man a woman. Rest everything British Parliament can do, but Indian Parliament is not supreme. So it has to obey the basic principles and the fundamental rights of the people of this country. And Article 368 is subjected to also scrutiny. The amendment Article 368 is also subjected to. So the debate that is going on in the country, actually our law minister always proclaiming, countering and objecting about the current judicial appointment process by the Supreme Court. So in that reference, the Vice President also made his statement. See, I'm telling you something facts about NJAC. The Vice President criticism aired by the Vice President of India. The basic structure concept, yes, basic structure concept actually emerged in the Keshwanand Bharati case 1973. The basic structure cannot be found in any particular article and goes beyond the written words of the constitutional text. This is the core characteristics. It denotes a set of principles which links all the provisions and makes the Constitution an organic whole. The Parliament is limited from making amendments which affects these core values of the basic structure of the Constitution. Each judges on the Keshwanand Bharati judgment had its own take on the Constitution basic essential features. These features included supremacy of the Constitution. What I am telling you, the Constitution is supreme. Nobody in this country is supreme. Nobody is above the law. That is rule of law. कानून का राज होगा इस देश पर. Separation of powers between legislature and executive and judiciary, and democratic character of the polity adopted into, incorporated into, enshrined into our Constitution. So the Supreme Court has held that its judicial pronouncement laid down the law. Article 141 of the Constitution mandates that a law declared by the Supreme Court is binding on all courts. जो भी कोर्ट्स भारत में काम करते हैं वो सुप्रीम कोर्ट की प्रोनाउंसमेंट, जो जजमेंट प्रोनाउंस करता है, उसके लिए बाध्य हैं अंडर आर्टिकल 141. जितने भी नीचे कोर्ट्स काम कर रही हैं वो सभी सुप्रीम कोर्ट के दिए गए गाइडलाइन, उसके द्वारा दिए गए डिसीजन को मानने के लिए बाध्य हैं. दे मस्ट हैव टू ओबे द इंडियन Supreme Court's directions, saying pronouncements, everything done by the Supreme Court. They must have to follow under Article 141. This is what the court has repeatedly been trying to convey to the government and high constitutional authority like Vice President Sri Dhankar ji in its oral judgments and orders recently. This is as long as NJAC judgment which affords the collegium system. Actually, this was challenged into the Supreme Court in 2015, and Supreme Court declined during judicial review. So the collegium system of judicial appointment exists. The court is bound to compel with the verdict. Parliament is free to bring a new law on judicial appointments, possibly through a constitutional amendments, but that too will be subjected judicial review. If amendment of the Constitution, that is also will subject to judicial review. The bench of Justice S.K. Kaul and A.K. Oka has told that Attorney General of India and Constitutional Authority that it is necessary that all follow the law as laid down by the court. Otherwise, sections of society may decide to follow their own course. एक्चुअली द जज ने कहा है कि अगर आप सुप्रीम कोर्ट के दिए गए गाइडलाइन और कॉन्स्टिट्यूशन में दिए गए प्रोविजंस को फॉलो नहीं करते हैं, उन्होंने गवर्नमेंट को कहा है, तो लोग फिर फ्री हैं, उनका जो मन करे वो करें. मीन्स anarchy. He is saying that it will be a consequence for you and your authority will be challenged. So don't violate the rule. He actually threatened the government. You have to go through the constitution. Don't violate it. If these are being violated, the people would have the right to choose their own path. Suppose that if police system and the authority system and judicial system is not able to deliver a simple person justice, then he will choose his own way. Either is extremism or violence, etc. Whatever if the society becomes violates the norms set out by the laws, then it would be the chaotic country. So you must have to follow the rules and regulations and go through the constitution, and we will have a good society. If you are not following the rules, there will be sanctions of society. They will follow their own course of action. Now the Supreme Court has remarked that judicial review, as was done in the case of NJAC law in 2014, diluted parliamentary sovereignty. In India, parliament is not sovereign. Okay? He had used sovereign means he has subjected to some kind of not a complete freedom. Okay? That doesn't mean that you are sovereign means you can violate, you have supremacy. Sovereign means can make the laws where Indian territories are there or Indian citizens are there. Indian Parliament laws made by the Indian Parliament is valid up to their citizen and the land. Okay. Now, the vice in the Keshwanand Bharati case, actually the vice president said that he had used terms such as one, upmanship. The vice president had said that he did not subscribe to the landmark Keshwanand Bharati judgment of 1973, which had proposed the idea of basic structure, upheld judicial review, and limited the parliamentary power under Article 368 to amend the Constitution. 368 जो आर्टिकल है, इसके तहत कॉन्स्टिट्यूशन को अमेंडमेंट किया जाता है और इसके द्वारा अमेंडमेंट किए गए प्रोविजंस को हम सुप्रीम कोर्ट में चैलेंज, हाई कोर्ट में भी चैलेंज कर सकते हैं और वहाँ पर इस प्रोसेस को जुडिशियल रिव्यू कहते हैं. ठीक है. अगर कॉन्स्टिट्यूशन सुप्रीम कोर्ट्स इस बात को पाते हैं कि ये बेसिक स्ट्रक्चर को वायलेशन है, तो वो इसे नल एंड वाइड घोषित कर सकते हैं. ठीक है. चेक्स एंड बैलेंस. At this very same Keshwanand Bharati verdict had made it clear that judicial review is not a mean to usurp parliament sovereignty, but only part of the system of checks and balance to ensure constitutional functionary do not exceed their limits. हर किसी के पास एक लिमिट्स है. हमारे फ्रीडम की अपनी एक लिमिट है. स्पीच करने की लिमिट, बोलने की लिमिट, मूव करने की लिमिट, चलने की लिमिट, हर चीज़ की अपनी एक लिमिट है कॉन्स्टिट्यूशन के अकॉर्डिंग, और मुझे उतना ही काम करना है जो मेरे लिमिटेशंस हैं। हर सिटीजन के पास राइट्स भी हैं, लेकिन उसके साथ ऑब्लिगेशंस भी हैं। वी आर unable to use how the power of judicial review makes the judicial super. We are unable to see how the power of judicial review makes the judiciary supreme in any sense of the word. This power is of the paramount importance to federal structure. एक्चुअली हमारा जो कॉन्स्टिट्यूशन इसमें फेडरल स्ट्रक्चर है, सेंट्रल गवर्नमेंट, स्टेट गवर्नमेंट, प्रेसिडेंट, गवर्नर, many various functions. Federal means there is 1, 2, 3, 4 systems operating into the system, and everybody has some power and some limitations. Okay, indeed, it has been said that the heart and core of the democracy lies into the judicial process. The top court observed into the Keshwananda Bharati case. Okay, so this has actually gone through, and the NJC Act was null and void declared by the 2015 judgment by the Chief Justice J.S. Kher. So this is all about, and every amendment done by the Parliament or the State Assembly must have to consistent and not to violate the basic structure of Indian Constitution. The basic structure is very basic concept, which is the ethos of the Constitution. If that is being diluted, that means is that the country is heading towards unknown future. It is necessary for India, in case of India, because India is very vibrant, very different background of their peoples, linguistic, cultural, ethical, ethnicity. So there is very much differences into the diversity in the country. So put out all of them into one cell, it is very hard. So you must have to part the power into different groups and make them equal. It's the only way forward for such a colorful country like India. So if you want to paint everybody's in the same color, that would be not good for this country because of the diversity. So we must have to go through the Constitution, and such a important personality who is the leading the India, Vice President, they must have to speak up according to the Constitution. They must have to think of, they are in the power right now, but this is they are only 5 years they will be in the power. So the Constitution will go to the many years. So I would say that it is good for future generation to respect the Constitution sovereignty and go through the Constitution. Otherwise we will have a undetermined and unpredictable future. So I'm not threatening anybody, but I'm putting my thoughts. Thank you very much.